The number you have reached, 911, has been changed to a non-published number.
Hi there, I'm your host Ken Lammers, and I want to welcome you again to another episode of Cltv. It's that time of week again, and I'm going to go through the 5 postings of the last week which most caught my eye. We're going to start out with one from a blog whose name I'm not actually sure of. It's got one thing in the URL, and it's got different things across the top of the blog. I think it's called Objection. It's a prosecutor blog, and he is talking about protection orders and all the things that go on around protection orders and how frustrating they are, and the most abused part of the system. I gotta agree with that, and I had this thought even when I was a defense attorney. I think that the protection orders are a frustrating thing to prosecutors and defense attorneys because they have to be there. And in Virginia, you can go get a protection order without going to the prosecutor first. They have to be there because there is a certain percentage of people that need them. Unfortunately, those of us that actually practice criminal law on a daily basis and are in domestic courts and all that have probably seen how abused this is as well. My personal opinion is that there's an absolute need. People who absolutely 100% need this, and they are somewhere between 5 to 10% of the people who actually take out protection orders. The rest of them are, usually women who got mad at their man or something, or God help us, the people who go out and take them as tools during divorce proceedings. And, we see these every day, and we've all seen the situation where, day 1, lady takes out protection order. Day 3, she's forgiven him, and they've moved back in together, and they're living together by the time they come back to court. Some of them are smart enough to lie about that, some aren't. And I used to get real frustrated with this as a defense attorney when the sheriff's deputies or the police officers would come up and arrest my client, the male, because he was living with the female after she invited him, in some cases pretty much begged him to come back. But I've seen where I'm at now, they actually have a way of handling that. Basically, if you're the male and you move back in, of course you're guilty of violating protection order. If you're the female who has asked or allowed or wheedled the guy into moving back in, then you're guilty of violating protection order as a principal in the second degree, which means someone who encourages it. I think actually that's a pretty good way of handling it. Yeah, it doesn't solve the problem. There's still entirely too many protection orders taken out, but it does somewhat clip the wings of those who would continue to abuse this. And it's something, I don't think the system can be fixed personally, because I think for that 5 to 10% who really, really need it, it has to be there. And the abuse is out there, and you can punish it after the fact, but you can't really at the beginning. Now, move on to Blonde Justice, and Blonde Justice is talking about how she is teaching some of her clients the basic rules that we all learned when we were 3, 4, or 5 years old, like don't take somebody else's property, particularly their wallet. And she goes on about how that's possibly if somebody had taught them these lessons when they were a little bit younger, they wouldn't be where they are today. Crime and federalism, which has started back up and is a bit sharper than it used to be, has a posting about sociopaths and compares it, actually points at the definition of sociopaths, basically people who are shameless and who seek pity all the time, as pretty much the definition of people who are in court as defendants, or at least a large portion of them. And I'd say it's probably right. I don't know what percentage of people are sociopaths. I remember being told at one point in the Army, I think it was, that it was about 10% of the population is sociopathic, not necessarily 100% sociopath. And that was in reaction to a question about why polygraphs were ineffective. And I won't go into why that question was being asked. But, you know, Mike's fairly correct. I mean, there are a large number of people who are in the, who are defendants, who either by nature or nurture are sociopathic, and they're really kind of shameless about what they do until, of course, they get caught, at which time they want pity for, you know, it's because of the way I was raised or because of the drugs I was taking and all that, some of which is true, but, you know, the pity is more of a play to get out of the punishment. Or at least that's one way of seeing it. Next we come to a public defender, and a public defender is talking about habeases and ethics. Basically it's a situation where, you know, habeas attorney 1 raises a claim because the defendant wants it raised, but doesn't really pursue it because he thinks it's a bogus claim, and then he gets habeased because he didn't do what the defendant wanted in the first habeas, and the appellate courts let him off because it was frivolous or, you know, a weak claim, and public defender is kind of going after him about that. You know, the problem here is what we see in a lot of criminal stuff, particularly if you're a defense counsel. You're either going to bring a claim because the defendant wants it, or you're going to get that bar complaint for not doing what the defendant wanted done. It's a no-win situation, and I can remember being at least one CLE where someone had worked in the appellate courts in Virginia said, yes, we realize this, and we realize that as defense attorney you're going to be forced to raise claims that just really are frivolous in your appeals, and don't really hold that against you. And I think that's truthful. I mean, I know when I was doing defense work and had to do appeals, there were several times where I had clients absolutely demand their right to appeal, and while I never filed an Andrews brief and was always kind of proud of that, I know it's a sin, but it was something I kind of, you know, took a little bit of pride in. But doggone, some of the appeals I've signed, or I've written, at the command of my client, you know, weren't much more than an Andrews brief. You know, they were the kind of sufficiency of the evidence appeals where you absolutely just know the Court of Appeals is going to destroy you. And I think these are the kind of situations where a lot of criminal lawyers get into. Now, I don't know in this case whether the habeas lawyer was appointed. I know in Virginia we don't appoint habeas lawyers, but if he's if the state he was in actually appointed the habeas attorney, he's in a bad situation, and he may have made the best he could out of it. If he's a hired attorney, I think he has a little bit less of an argument because, well, he chose to come in, and you know, before he chose to come in, he could have, should have told the defendant, no, I'm not going to do that claim because it. And finally, we come to of counsel, and of counsel is talking about, well, the latest update of counsel has, of course, become our 24/7 coverage of the Nichols trial and its failure to go forward because of money reasons. And of counsel, you know, briefs us a little bit that this is not just going on in this case, that money's been tight everywhere, that in indigent defense in Georgia, apparently outside of the PD's offices, of course, that when people are getting appointed outside of the PD's offices, money's running out on other cases too. Apparently one other murder case, the appointed attorneys basically asked that the case be, you know, delayed or whatever because there was no more money. They weren't getting paid, and and you still got bills to pay, and the judge just took them off and put the local public defender on, which is not something you do in Georgia because there's now a statewide capital defender's office, which is something that's been popping up all over the country. So he also talks about Nichols, how they're starting to shuffle people because of the same money problems. The case has been stalled because the judge refuses to force it to go forward without money to pay the defense counsel, and so now what's going on is they're starting to shuffle who's in defense counsel so that it can get forward. I would recommend you keep following of counsel. Seems to be on the spot for whatever's going on in this case. And ladies and gentlemen, I think that's it for this week. I wish you a happy week, and I don't know if I'll have something up for Monday. I'll try to, but I plan on spending the weekend in central Kentucky, going to watch at least my college play basketball, because as anybody who's seen my blog in the last week or so knows, my college center is ranked 14th in the nation in D3, and it's going to play the 18th college in the nation, Millsaps, at home this Friday. And I think my high school, Bryan Station, which is ranked first in Kentucky, may have a home game this weekend. I'm not sure about that. I got to check. But so I'll probably I'll probably go to a sports bar and watch the UK game on Saturday. So I will probably be neck deep in basketball for the weekend, which is pretty much hog heaven for those of us that grew up in Kentucky. So ladies and gentlemen, I'll see you next week, and we'll see what the best 5 are in the coming week.